So I warmly welcome you to our today's webinar. It's about the AI regulation and licensing contracts, a webinar on navigating the legal landscape. It's presented by Maria Rehbinder and me, Judith Ludwig. Um, we're both um, we're both members of the Copyright and Legal Matters Working Group. And in the chat, we have Hannah. Also, you can see her under Liebe Euro. She's also checking the chat, and as she already said, in the chat, please write them here, and we'll have time to answer your questions always after the presentation. So, what are we planning to do? We have the agenda, and at first Maria Rehbinder will tell you something or give a presentation about the AI Act and its implication, and I'll try to give also some practical guidance on the second part of this webinar, which is about the national example, Germany, where I'm going to present some what we did with the arrangements on artificial intelligence and license agreements, and I'll present TIPS AI policy. And now we're coming to who's LIBE actually, because this is a webinar which is open not only for LIBE members, but for everyone. And at the beginning, LIBE was we were just a few founders, which started in 1971, and now we're a big network of 40 different countries and an open library network. We're now currently 420 libraries who are member of the LIBE, and we're devoted to open science and world-class research. That's what we're trying to bring into the world, or especially also bring it to Europe. Therefore, I would really like to invite you to our annual conference, which is this year in Lausanne in Switzerland. There are almost in the last year, within the last year, it has been attended by more than 400 research library professionals. We'll have the classic keynote speakers, workshops, social events. It's a really good place to start the networking, to have a look what is going on in Europe within or in the library world. I think we can put the link into the chat to the annual conference if you would like to have some more feedback, but I'm also quite sure that you're able to Google the keywords and find the specific website on that, which would be then LIBE annual conference. So who's the LIBE Copyright and Legal Matters Working Group? Maria and me, we're member of the working group. I'm the co-chair together with Alex Fandon from the head of copyright and licensing unit from the University of Birmingham, and Susan Riley, who's the director of the Irish Research Library. And we're just a group of librarians, lawyers, professors, and communication professionals, where we're discussing on a monthly basis the most important acts or things that happen within Europe, especially like currently we have like the discussions about the AI Act while we're having this webinar today. But we're also just act as a forum where we're sharing our information and knowledge, like what is going on in your country right now, what is discussed right now, so that we're just keep each other up to date on the legal and especially on the copyright basis. So whenever you feel like that you would like to join us, feel free to send me an email or go to our website, which is also written down there, and try to get in contact with us. We're happy always for new faces who would like to discuss with us legal matters or especially copyright matters. So also as a work from our working group, we had a project last year, which ended now in an open consultation, which means that we tried to condense like a really specific report and now we wanted to condense these information into an easy action plan for scientific libraries, how we could improve the access and the reuse of research results. And here we wrote an action plan. And now we would be really, really happy to receive some feedback from you, like if it's understandable, if you would like to add something, if it helps. And the consultation is open until March the 7th. We just extended also the deadline. I think think Hannah will put the link into the chat. I'm not able to see the chat right now, so I'm just assume that you'll have the chat, the link with you. And please do read our action plan and comment on that. Because this would be also, I wrote it, or I called it homework number 1. Please give feedback to the action plan, because this would really be helpful also for us and our work. And as a second homework or question, I'd like to ask you before you really get the information while you're here, or we start the webinar while you're all here. Also, we would kindly ask you to give us some feedback about this webinar, because we're also going to ask some questions like, do you have any guidance on copyright or on AI on your national ground? And there we would be really happy to receive some links, because sometimes, even though I just said that it would be really helpful if you could just Google like the keywords, sometimes you just need to know the keywords before you can Google something. So that would be really helpful if you could also fill in the survey that we prepared after the webinar. But I just wanted to give you like a short expectation, so that you know what we would really like to know from you. So coming back to the agenda, I now hand over to my dear colleague Maria Rehbinder, and she will present the AI questions. I'll give you the control, Maria, and you have the control, and I'll hand over to Maria. Thank you.
Thank you, Judith, and welcome also from my part. I'm a lawyer at Aalto University, and I also give advice on copyright advisory services of art universities in Finland. And I have been active in Liber since the lobbying around digital single market directive, which we will discuss today. So here is a picture of my university, Aalto University. It combines the technical university, the design school, design and architecture school, and the business school. And we have about 20,000 students. I've been doing copyright law for over 30 years. And now I'm excited about the new development with artificial intelligence, which gives new questions and hopefully also new answers to the basic copyright questions. So I want to introduce some definitions. The Consultation on Data Act that Judith presented also has questions on definitions, and I think we are quite lucky in EU that you say that EU is the Silicon Valley of regulation, and our regulation has very good definitions, for example, related to research data and other types of data. We have over 60 definitions in the RE Act. The RE Act started as product safety legislation proposal from the EU Commission. And that proposal is actually quite logical and quite easy to understand and much version. And then it didn't regulate artificial intelligence as systems or models as technology, but it legislated specific operations that posed high risk or unacceptable risk to health, safety, or fundamental rights. And this part still stays in the RE Act, the part about RE systems, but the original proposal had nothing on copyright because it was not a legislation on technology, it was legislation on risky use cases of RE. But and I'm going to tell just the general concept of what are these risky cases that are still regulated in the RE Act. So these use cases are consider RE systems. So and these are consumer-facing systems, and the RE Act has a market-based logic. So deploying or bringing to the market, placing on the market RE systems that manipulate people, taking advantage of vulnerable groups, social scoring, a categorization of people based on biometric identification, and for example, facial recognition systems in public spaces. These are unacceptable practice. They are prohibited, but there are always exceptions and, for example, law enforcement purposes. Then the majority of RE Act is about high-risk RE systems, and there is a list of EU product safety legislation, and these are high-risk systems that are then in an Annex 1 of the RE Act. For example, cars, medical devices, and lifts. So if you researchers are researching on these areas, it's good to know that the products that will be placed on the market will have obligations on RE Act. And then there are also specific operation areas that are considered high risk, and these are typically operation areas that are linked to a certain fundamental right described in the Charter of Fundamental Rights of EU, for example, the right to education. So if you have an RE system that scores the people trying to get into university, then that is a high risk RE system, because that influences if the students get to the university where they want to study or not. So it influences on their right to education. Then the third group that is legislated in RE Act are the transparency requirements. These are not high risk or unacceptable risk, but they have to comply with transparency requirements. So here, the risk to people and to rights such as democracy come from the lack of transparency. So here, you have the obligation for the providers to design the system so that it discloses that the content the RE system generates was generated by an RE system. And also the providers of these RE systems have to design the model to prevent it from generating illegal content. You have to, if you produce deep fakes, you have to mark them as generated by an RE system. And then one transparency requirement is on copyright. So you have to publish summaries of the copyright protected data used for training. And this is not only actually copyright protected, but also data that is protected by the sui generis right in EU or by related rights. And this short introduction to RE is actually from the European Parliament webpage, so you can look it up there. I mean, these links are meant as sources. I'm not going to go through over their content here. So the center is the RE system, So I Act, and we are not going to talk today about artificial intelligence as a philosophical question. I'm only going to talk about AI system and general purpose AI model, which are aspects which are defined in the AI Act. So AI system is defined as a machine-based system that is designed to operate with varying levels of autonomy. And the Commission AI Office has published guidance on what this means, the AI system, and this having some level of autonomy is something that is required. So if it doesn't have autonomy, if it's a rule-based system where you can always predict accurately the outcome, then it's not that kind of AI system that is meant in the AI Act. And another, what is required is that it can influence physical or virtual environments, like in my example of the student trying to get into university. If the AI system grades his entrance exam, then it has an influence on that person. So there has to be an influence. If it doesn't have an influence and a high risk, unacceptable risk, or risk from transparency, then it's not in the scope of AI Act. So as I said, the AI Act is not legislation on technology. So AI models are algorithms trained to perform predictions or analysis. So AI models in general are not regulated, but in the legislative process of the AI Act, the Parliament added the general purpose AI model. And an example of these are the large language models like ChatGPT. And these are then considered to have so much impact on the internal market that they are regulated. And these can then be integrated into a variety of downstream systems on applications. And here is also an exception. One of the purposes of AI Act is to enable research and development in the EU internal market. So here again, also for the general purpose AI model, this regulation doesn't consider AI models that are used for research, development, or prototyping activities before they are placed on the market. But of course, when you are doing the research at your library, if you know that the end result will be placed on the market, then you, for example, have to already gather the copyright training, the information on what copyright protected training material it was trained on, because you're going to need it later on when it's when the end product, the general purpose AI model or the system containing it will be placed on the market. And like I said, over 60 definitions in the AI Act. There are many data definitions in the Article 3. Training data, validation data, testing data, input data. And for all of these data types, the text and data mining exception that is legislated in your national legislation, hopefully, and that is regulated in the digital single market Article 2, 3, and 4 applies. And the definition for text and data mining is very wide. It means any automated analytical technique aimed at analyzing text and data in digital form in order to generate information. And then the information for the training model, it's actually often given as vector numbers, numbers of vectors or vectors of numbers. But we are not going to go in there today. But using copyright protected data or words, texts, images as training data is in the scope of text and data mining as defined in DSM Directive Article 2. And the RE Act refers to the Digital Single Market Directive, so the Directive 2019-7090 of the European Parliament on copyright and related rights in the digital single market. The reference to digital single market, the copyright in digital single market directive is in Article 53 of the RE Act. Okay, there's my first spelling mistake. So it should be also big R, big E. Okay, so Article 53, obligations for providers of general purpose RE models. Providers of general purpose RE models shall put in place a policy to comply with union law on copyright and to respect the reservation of rights expressed in Article 4, Section 3 of the DSM Directive. And providers of general purpose RE models, so for example, OpenRE, if it brings a large language model to the EU market, then that OpenRE company would be a provider for a general purpose RE model. And that company would have to draw up and make publicly available a sufficiently detailed summary about the content used for training of the general purpose RE model according to a template provided by the RE office. And the RE office is an office of the EU Commission that gives out this template, and I have a link to that, hopefully in the presentation. If not, I'll share it in the chat. And the first draft for the template has already been published by the Commission. Yes, I have it here. The template for the summary of training data. So the providers, which are the commercial companies that are placing this general purpose RE model on the EU market, have obligations related to transparency. And the template is given by the RE office, and then there's a code of practice which is facilitated by the RE office. And these are both now being discussed. The obligations in Article 53 start to apply on the 2nd of August next summer, 25. So we will get the final template and hopefully the final code of practice before we have to apply that. We already have the prohibited practices applied from the 2nd of February. For those obligations, Commission released the guidance 2 days after the obligations started to apply. So let's see what happens here. And IACT refers to DSM Directive Article number 4 and Section 3. So the Article number 4 is the general exception for text and data mining. It's not the it is not the one for research organizations, which is a mandatory exception. The AI Act has no reference to the mandatory exception, and as I will discuss, research and development are outside the scope of the AI Act. But the general text and data mining exception is referred to, and in that Section 3, you can also do text and data mining if you are an other company, for example, a Silo AI, which what used to be a Finnish AI laboratory company, on the condition that the right holders of the copyright protected material have not reserved their right to the, so this is an opt-out. So for example, if you have a web page, you can place their robotext file telling the web crawlers that in a machine readable way that it is not allowed to use the copyright protected material on that web page, or actually the whole web page. The web crawler of the AI company has disallow, so it's not allowed to copy the material on that web page. So this is the reference to DSM directive, and the DSM directive also has the mandatory exception for scientific research, and this is for the we are discussing this what is the scope of this, but this is at least for the EU right holders, and then it's possible that also the RE Act, which has the Brussels effect and which says that all RE companies that train their AI models have to comply with EU copyright legislation. It's possible to understand that the RE Act is trying at least to make the DSM directive obligations global instead of just applying to EU rights holders. But that's an ongoing discussion. So provider means natural legal purpose person who develops an AI system or a general purpose AI model, or has them developed and places it on the market. So now we are just discussing the general purpose AI model, so places it on the market, and only providers that place general purpose AI models on the market are on scope. And placing on the market is defined as something that happens in the course of commercial activities. So only providers that are general purpose model providers and place that on the union market as part of commercial activities are in scope from the AI models. Then AI systems are also in the scope. The AI systems are the consumer-facing systems such as the ChatGPT. So if a regular consumer like me can use the AI system, then it's an AI system. But if it's the AI model, then it has only the only the general purpose AI model is regulated. And this code of practice draft written by independent experts and facilitated by the AI office is published, and there it says that you should use the robots exclusion protocol, and also there's discussion on if there are other ways to explain that the RE companies should not use their crawlers on your web page. This robots exclusion protocol is really widely used. It was drafted already in 1994, and it's updated and provided by the Internet Engineering Task Force. It's request for comments, RFC 9309. And so that's also a public document. It is not yet, it is a proposed standard, but it's not yet a standard. But as I said, 30 years of wide use. On every web page, you have the robots exclusion protocol telling web crawlers what they can do and what they cannot do, and that is also referred to in the code of practice, and that is the way for right holders on the internet page to prevent their material from being used as training data if they so wish. So this code of practice is being discussed. The United States AI companies say that it is there's too much regulation there, or too many requirements, and the civil society organizations that are worried about human rights say that it's not enough requirements, and the EU's digital chief, Henna Virkkunen, from the Commission, who has she's the person in the Commission in charge of the RE compliance, has stated that the Commission will try to interpret the RE Act in a way that would enable research and development and human-centric and safe use of RE in the Union, and that European values will be protected. As I said, they are written in the Charter of EU Fundamental Rights. But let's see how this, it has turned out that drafting the code of practice is very difficult, because the RE Act relies on different stakeholders reaching a compromise, and the RE office is only facilitating this. The template the RE office will provide alone, so that will be done at least. The template has this information. So number 2 is list of data sources. So any data that is used should be listed, but if you have, it is not required that you list every web page that your crawler has crawled. It is some percentage of web pages or sources that you have to tell. But this is quite detailed, but it's maybe better if you look at the template yourself, but this is the level where the draft for the template is now. And then a few words on the scope of RE Act. About the DSM directive output. Like I said, there's ongoing discussion on how this opt-out requirement applies. At least EU rights holders have to expressly reserve their rights. And would RE Act scope have the Brussels effect to opt out? It remains to be discussed. At least the scope is to all providers who provide the RE systems on the general purpose RE systems or the general purpose in the Union. So all providers are in scope. So the RE Act has the Brussels effect, but does the DSM directive also have the Brussels effect? That's the question. And as I mentioned, placing on the market is an act of making available on the market, which means supply of an RE system or general purpose RE model for distribution or use on the Union market in the course of commercial activity, whether in return for payment or free of charge. So if you have the RE system which you can use free, of course, when it's free, you are the product and you pay with your personal data or with your photographs or some other data. But the provider obligations come to the company doing this in the course of commercial activity. I don't see, at least my university, becoming the provider, because even if we would look at some research that we sell to a company, when we sell the research service, then the company also gets the result, and the company will be the one placing the product or service on the market, not university. So I don't see university doing RE research in the role of provider, at least not the way my university works. Also, there is a carve out in the scope, Article 2 of RE Act. Regulation does not apply to RE systems released under free and open source licenses unless they are high risk. And this is a bit, I think the exceptions are actually quite confusing because if you're not placing, if you think of RE models, they are quite confusing because RE models are not regulated if they are not general purpose RE models, and RE systems are then consumer facing systems. So, but a regulation doesn't apply to RE systems released under free and open source licenses unless they are high risk, prohibit risk, or have transparency obligations. And so it has no relevance to the models released by university. They are not in scope. And then research and development are not in scope. Maybe here interesting is to note the development. So the DSM directive also has the Article 3 for research organizations doing scientific research, but here this exception is very wide. So anything developed and put into service for the sole purpose of scientific research and development is not in scope, and the regulation does not apply to research, testing, or development activity regarding RE systems or RE models prior to being placed on the market or put into service. So, of course, all other legislation like copyright law personal data legislation still applies. And testing in real, if you test an AI system that is high risk on consumers in real world conditions, then you are in the scope. So here it's for testing in real life, for testing AI systems in real life conditions, there the university research activities can be in the scope of AI Act. And then few words about the autonomy. So the autonomy of the AI system, remember the definition, makes it different from other tools controlled by the author like Photoshop. Autonomy aspect is very meaningful when we look at the requirement of originality, requirement for protection. So Court of Justice of the European Union has defined in its case law that copyright can only apply to subject that is original in the sense that its author's own intellectual creation reflects the author's personality, and the author was able to express his creative abilities by making free and creative choices. So obviously, when you are using an AI system, this is not what happens. You are not expressing your personality, you're not making free and creative choices. So we already have a court case from Europe on this. There was actually, this was quite funny because two law offices made this happen. So a person prompted the AI system, I think it was dull, that two lawyers shaking hands in a Prague law office, and the claimant wanted copyright protection. He claimed that the other lawyers had used his image without permission, and he said that it was created on the basis of my specific prompt, and this prompt gives me copyright protection. But the court considered that the prompt could only be regarded as a theme or idea for a work, and theme and or idea for a work cannot be protected by copyright. So here we have the again the first instance court, municipal court. So image is not a copyright protected work, and this would also be the case in Finland if this was decided in Finland. Then we have a case from United States where you can register your copyright. So this is the Copyright Office decision. They look very closely at how Midjourney creates images. So the technical side was very carefully examined, the whole case with all the pictures and all the very long and very good analysis is behind that link. I will share these slides in PowerPoint form, not as a PDF, so you can access all the links when you get the slides. The United States Copyright Office noticed that Midjourney converts words and phrases into smaller tokens that are used for the training data and to generate image. The process is not controlled by user. It's not possible to predict what Midjourney will create. So these are not original works of authorship protected by copyright. There's also a court case with the same result, stating that yes, copyright is designed to adapt with times, but underlying that adaptability is the understanding that human creativity is the core requirement for copyrightability, and this is now lacking when using at least the tools available now. I also have here links to Aalto University guidance on responsible use of artificial intelligence in research. Then we have some guidance also for teaching and learning, and then artificial intelligence systems and copyright, which is written by me. And in those advice, we give advice on how to cite outputs of AI system. Many of the reference styles already give that. Here's a link to APA on how to cite ChatGPT. And this is how I cite when I use generative AI generated content. So I use the APA style, but I also add some information there. So this is very popular at my university, that teachers always have the problem on how to get images, so they use images generated by an AI system, and we now have also bought in-house an AI system where we have the agreements and we know how that works, so it's not free. So thank you, and I'm looking forward to your questions at the end of Judith's presentation. Thank you for your patience, and I give the floor back to Judith. Thank you, Judith.
So my part today is to show you a national example, how we tried to act with the AI Act and with the all the AI changings. Therefore, it's not like that is what everyone in Germany does. It's only what the Technische Informationsbibliothek, where I'm working at, is trying to handle the AI revolution, or the smart revolution, how you might say. So just a few words to my university, or to TIB, where the German National Library of Science and Technology, and on the one hand we're a university library, but on the other hand we're a member of the Leibniz Association, so we're a scientific infrastructure center. And yeah, we're doing also quite a lot of research, and trying to make it easier to achieve and understand the information. Just a few words to my person. I'm a fully qualified German lawyer in Germany, even though I'm not a named lawyer, but I have all the bar exams that you need to be a lawyer. And I'm working as the general counsel at TIB, and I'm also working as a license manager at TIB. And now we get into my first presentation, which shall be about the arrangements on artificial intelligence and license agreements, which it's like a short overview how we decided to master the smart transformation that we're already having, or that we've that came within the last years. We do have the legal law, or the European law, or hopefully also the national law, what we're more or less allowed to, or what not, according to speaking about text and data mining. And training AI is still a little bit unclear. So that's why we're having we faced an unclear legal situation. And once the situation is unclear, you rather, or especially libraries, tend to rather not take the risk, and rather just do what is really, where we're sure that it's lawful, and otherwise we just don't do it. And this means that we saw, especially in Germany, and when we're speaking about license agreements, that we had a chilling effect, because in a lot of agreements we had like text and data mining clauses, or clauses referring to the usage of AI, or for training generative AI, that it's completely forbidden. And there was a huge confusion in the first quarter of 2024, because somehow it was text and data mining is allowed for scientific purposes. Somehow license agreements said that any kind of TDM or training of generative AI would be is not allowed by the terms of use in the license agreement. And so, at least in Germany, we started a task force with 6 legal experts, and we tried to write down just some recommendation for action where we really could say, okay, this is legally clear, that we're allowed to do this. And this was covered or actually convened by the Alliance of Science Organizations in Germany. And next slide. So here at first, this we had a we started to at first analyze like what is actually artificial intelligence. Like Maria already said, that artificial intelligence is like a really broad field because everyone understands somehow artificial intelligence in a different way. The most regulated way to understand artificial intelligence is like the one in the AI Act, where it's like, but this is also a really broad definition, but because somehow it covers everything. But you should always, whenever you're negotiating a license agreement and you're speaking about artificial intelligence, that you should somehow explain what you understand under artificial intelligence. And there, we would suggest to either really specify what you're meaning and what you expressly want to say, like giving examples of something, or you just use the definition of the AI Act. So that, but then you need to be sure that it's really broad. Then again, we clarified in our publication that the country of the protection principle means that whenever you use a work, a copyright protected work in your country, that the copyright law of your country applies to the use of this copyright work. And this is what is a really important principle to know, that whenever you use something in Germany and you know that it's covered by your copyright law, then it's not unlawful. This was also something that was really needed to clear it up, at least in Germany, that on the one hand, you have the library who's agreeing on licensing agreements, but on the other hand, you have the users who are using something, and where's the liability for the user and where's the liability for the libraries. And therefore, so we don't see that a user can be liable when he or she is using the copyright protected work in a way German copyright allows the usage appropriately, even though it says, for example, TDM in the license agreement, it says TDM for scientific purposes is not allowed, and then the user uses the copyright protected work for text and data mining for scientific purposes, then the user at least is not liable. And another word is, or another thing that is really important, or what was really important for Germany to manifest again, is that the contracts cannot effectively prohibit any or can prohibit the text and data mining as or using works as input data for AI training. This is also something that Maria just referred to from the DSM directive, that contracts just cannot effectively prohibit text and data mining for scientific usages. And this is also something we cleared up in Germany within our publication, just to make sure, because not everyone wants to read always the German Copyright Act, and sometimes, yeah, you just need to try to put something in a nutshell. As a second, or as another manifesto, we also cleared up that temporary reproduction is always permitted as long as it's only fleeting or incidental, so like the classical streaming, and as long as it has no economic significance of its own. So when you don't have any, for me it's always like the standard or the standard understanding of this clearing as like the streaming. Like you just do a little short copy just to use it in a different way, or just to see it, but you don't really keep the copy itself. You just do the streaming. And then as well, also in German copyright law, we say that, or it's regulated actually by law, that contracts concluded on or after March 1st cannot effectively restrict, especially text and data mining, the usage of text and data mining of copyrighted protected works for scientific purposes. So whatever is written in any license agreement, which has been concluded after March 1st, and whenever it says text and data mining in general is not allowed, this is an unlawful clause in the agreement. So that you actually always have the right as library or as researcher to do text and data mining for scientific purposes, no matter what's written in the contract. Now we're coming back to the question. So do libraries have to tell the publishers that we're going to do it anyway, or that we and that the regulations that you're having in your contract are overridden by national copyright? There is no clear opinion on that so far, and we can discuss this later, but or maybe we should discuss this later, but this is really like a broad discussion we can lead. So, but what I'll just keep on going on my presentation. So furthermore, on our publication, we also try to clear up that we cannot, that contracts may stipulate measures to ensure the security integrity of networks and databases through appropriate security precautions, and also may stipulate requirements for copies made within the framework of text and data mining. This means the publisher can always, or also the contract can always say what is needed for security reasons. So, for example, you cannot the publisher could say, okay, if you want to do text and data mining for scientific purposes, we provide you with a special API where your researchers, or through which the researchers can access our content or your licensed content and do text and data mining. So you don't have, so that we can at least somehow channel the text and data mining works from your researchers, because otherwise our server would collapse, because if every university would only just let one scientist do text and data mining on on one special publisher's server, it will be such a big data pressure on the server that it probably the normal function would not be anymore, or could not be guaranteed anymore. So therefore, that is something that you can discuss in the contract, and maybe also should negotiate in the contract, not if text and data mining is allowed, because this is ruled by European law, or hopefully also by your national law. You should discuss in the license agreement how text and data mining is provided to your researchers, with your researchers, and this is something that could be that should be discussed in license agreements. Also, for sure, just for clearing things up, the Creative Commons licenses are not covered or cannot be restricted by the license agreements, because this is like a special license, the CC BY license, or the Creative Commons license, and there there, and of course, there are also like the CC BY NC, CC BY ND, and CC BY NC and D licenses that they might be a little bit more tricky to do text and data mining out of these licenses, but still, they cannot restrict it by the context. So to put it in a short, quick overview, you can copyright protect works use as input data. This is allowed by German copyright law. You can use it as, so it's only the input data, it's not the training data, but the use of training data basically requires permission according to German law. And in the context of text and data mining for scientific purposes, with the AI processing activities, whatever, with a non-public usage is absolutely permitted by German law. But again, you can discuss, or also publishers can give you like some restrictions due to integrity and security of the database. Another point of view is, of course, the text and data mining, which is not for scientific purposes, and this is in general permitted, but you can also, as a rights holder, you can also deny this usage for text and data mining. This is also where Maria just referred to, that they can deny this via a machine readable version. So yes. Then again, within the framework for machine assisted cataloging or indexing, like just a normal, what we mainly as librarians or as libraries want, we really would like to, or we really need or might use the metadata or the data that we have also just for indexing, just to show, okay, we somehow use the works that we're having, and we use, for example, some AI for making it easier to access the works, or to find the works. So for indexing the work, this is expressively allowed by law, by German copyright law, also for libraries. And yeah, for sure, we had our European Accessibility Act webinar last week for the benefit of the blind, or for accessibility reasons. You can also always use the copyright protected work for the benefit of those users who were covered. So, and to put it in a nutshell, or to wrap things up, so the requirement for any AI clause is that you should not accept any blanket wording of artificial intelligence or a generative AI. You should rather try to use the definitions of the AI Act, especially when you're closing your agreement with publishers who are not based in the European Union. So there should not be any ban on pure data analysis or any AI methods. So, because this is like too broad. And also the clarification that users in the internal system of an institution for scientific research purposes, that they are allowed. And again, another really important thing is that when you're negotiating a contract, that there should not be a special liability rule, or at least you should make sure that your library is not liable for breaches out of the contract by the users, and yeah, unless the institution caused knowingly or encouraged or tolerated this breach of contract. But this is also always a very important thing. You have to check when you negotiate license agreements that the liability is not or is really, really small, especially for your users. Um, Another or some other nice to haves would be that you could add to your license agreement that that the users permitted to the institution and users are under applicable law shall remain unaffected. So this is again clears up that whatever the lex loci protectionis we just spoke about, that whenever it's covered by law, then it's covered by the copyright law, and that affects to the usage of the specific specific work. So actually, it's it's a principle. So most of the publishers do or should know them, but just to clear it up. And for sure, your choice of laws should always be in favor of your national law for the license agreement. I know a lot of license agreements are covered by the laws of the specific publisher where he has a seat, but it's always I would always say that you should try to give either way your national law for the license agreement or just remain silent about the choice of law question, because this means how your contract will be judged and within which national law it will be judged by the court you accept. And I mean, everyone is somehow fit within your personal or your national law, but you're not fit within the law of the publishers probably. So that's why you should always try to keep your national law to the license agreement. Now I'm gonna give you a short overview about TIB's AI policy. We provided this policy really quickly for our researchers. And I just would like to show you how you could maybe handle the AI mess coming or drowning on you, and how you maybe try to have your library to have like clear rules for a safe usages of generative AI or AI systems in general. We had quite a lot of discussions within our management about it, how we would like to handle the AI and or the AI questions that are coming to the legal office. And at first, as TIB, we wanted to highlight that TIB supports the use and development of systems that operate with the help of artificial intelligence systems. So we wanted to encourage our researchers to use and to figure out how AI is working, how AI systems are working, how we can maybe improve our working with it. But still, we made like some rules. So the first rule was that we said that the users are always or shall be responsible for complying with our guidelines when using AI systems. So you need to make sure before you use the AI system who's responsible for it, what are you doing with it, and why are you doing it. And then we also recommended that before you use an AI system, you should check how you use the specific AI system or the specific SI, and that you need to involve like the responsible bodies such as data protection or the legal office, depending on what are you doing. So, and as a third part, we said that the use of AI must be sufficiently transparent. For example, also like how Maria just showed, how you quote like your prompts when you use an AI AI generated picture, that you say, hey, I generated it with AI and I used this prompt. And for example, and especially you also need to comply with the good scientific practices that we're also having in our institution. You should have a risk control before using an AI tool, and you should also define and make transparent and also be able to control it at any early stage. This is especially when you're really using AI systems for research or for like some higher working. Then of course we said that you always need like the security, or have to think about the security, and that the confidentiality and integrity of AI systems should be ensured, and especially also the information used there. So for example, when you shouldn't put it into the AI generative AI system personal data or own or foreign secrets. And you also need to somehow think about suitable measures to prevent any misuse of the AI system. Then, of course, the data protection part. Whenever you use any personal data, you need to inform your data protection officer, or it needs to comply with the data protection regulations we're having in our library, and also within the intellectual property parts, that whenever there might be some copyright protected work used to train generative AI systems, or to yeah, or just to use copyright protected to just analyze it with AI systems, you need to make sure that at least the results are not similar to any original works, and also the legal office should be always involved and should be asked before using the AI system. And then for sure, you always have to ask yourself whether you really need to use this AI system. You should think about the financial part on the one hand, about the personal part, but you can also think about the environmental part, that any question you're asking ChatGPT may also like cost some energy, that you maybe also just use it within your brain. So these are like the eight like eight rules we brought up for a safe use. It's nothing really like, it's not a law or like you have to do that, but it's like really that you, once you feel insecure, whatever, you get a guideline what to do with within the TIB when you want to use AI, and what you should consider. And the second rule we linked to an annex. Here we tried to help our colleagues to somehow cluster the AI acts purposes, or the AI act systems, and what is permitted and what is not permitted, and what you should think about, especially whenever you're using an AI system as a research system, or whenever your AI system is a high risk system, or just just a working aid or whatever. So here we try to make it as easy as possible to understand the whole complex situation. We're aware that it's not like and it does not cover everything and any specific question, but it helps and gives some guidance to our colleagues, like how to handle generative AI tools, or how to do research with AI, and so we can work on that even better. So, and we implemented it so one thing was really sure, that it needed to be adapted really quickly and flexible, because that's why we only gave like in the policy a general overview on the matter. And we have in the internal area of TIB, we have like an information page where we update the specific changings, or we have FAQs. We also bring on like internal workshops where we try to explain and make artificial intelligence understandable to all of our colleagues, and we just try to stay let's say, in touch with our colleagues, like how they use AI, because once we can use it for research purposes, the other person is using ChatGPT just for answering emails in a nice way. And so there are so many reasons or possibilities to use AI systems that you can't really put it under one strict policy. So you really we needed a broad policy where we can just give like some ideas what you should or what you should think about when you consider to use AI for any purposes. So that was actually like a really quick overview about our AI policy.